Welcome to your friendly neighborhood historian, where we discuss just enough history to inform, intrigue, and entertain. I'm Bill Petro. The history of presidents opposing the Supreme Court, the separation of powers. The question on many people's minds right now is, what's going on between the president and the Supreme Court? How does the separation of powers between the U.S. government's executive, judicial, and legislative branches work? A more helpful question, to put it in historical perspective, is, have any U.S. presidents either ignored or opposed the dictates of the Supreme Court? And what can we learn from this history? The short answer may be surprising, but the longer answer is more intriguing. Short answer, yes. It's happened at least 10 times in American history. The longer answer is, sometimes the presidents succeeded, sometimes they didn't. Is there a difference between ignoring the Supreme Court and opposing the Supreme Court? Not much. In both cases, these words describe presidential defiance of the Supreme Court. However, there is a difference in the level of acrimoniousness. Outright defiance by the president has occasionally been called a constitutional crisis, challenging the separation of powers doctrine in the Constitution, with significant legal and political consequences. But ultimately, it all depends on how it plays out. Nevertheless, there have been several overt presidential defiances over the past 2+ centuries of our constitutional history, and others where they simply quietly ignored the dictates of the judicial branch of the government. Starting with the two most notable examples from the 1800s, in 1832, President Andrew Jackson defied the Supreme Court on ancestral lands. The first U.S. president most commonly associated with defying the federal court system was Andrew Jackson. He consistently advocated for the relocation of Cherokee individuals from their ancestral lands in Georgia. In 1830, he enacted the Indian Removal Act, which conferred upon the president the authority to regulate interactions between the federal government and Native American tribes. But even the U.S. Congressman from Tennessee, Davy Crockett, argued that President Jackson was violating the Constitution by refusing to enforce treaties that guaranteed Indian land rights. The Supreme Court decided in Worcester versus Georgia that Native American nations were sovereign entities, and only the United States, not the state of Georgia, possessed the authority to negotiate land and territory agreements. The act conferred upon the Cherokee Nation the full rights to their land within Georgia. Jackson reportedly responded to this ruling against him with the famous remark about the Chief Justice of the Supreme Court. John Marshall has made his decision, now let him enforce it. Jackson permitted the Georgia government and militia to encroach upon Cherokee territory, which ultimately resulted in the forced relocation of Cherokee individuals from Georgia, now known as the Trail of Tears. While Jackson's actions were controversial and ignited substantial debate regarding the checks and balances among the governmental branches, his response to the court's ruling amounted to a fundamental refusal to comply with the Supreme Court's decision. This act of defiance toward the court's authority remains one of the most prominent instances of a president disregarding the judicial branch's prerogatives. Score: President 1, Supreme Court 0. In 1871, Abraham Lincoln was refused the power to suspend the writ of habeas corpus. At the beginning of the Civil War, there were local riots and uprisings from Confederate sympathizers. President Abraham Lincoln suspended the writ of habeas corpus, allowing him to arrest Confederate sympathizers without a trial. Habeas corpus, from the Latin "you should have the body," is a legal principle that protects an individual from being unlawfully imprisoned without bringing that individual before the court to justify the reason for their detention. The Supreme Court ruled that only Congress possessed the authority to suspend habeas corpus. This episode was called the Ex parte Merryman case. Despite Lincoln and the U.S. Army's defiance of the order throughout the Civil War, Congress eventually acknowledged its validity through a retroactive declaration. Congress officially suspended habeas corpus in 1863, 2 years after the case was filed. Score: President 1, Supreme Court nothing. Now, during the last century of American history, there have been well-known and more obscure examples, but with fewer presidential successes. Take, for example, Franklin D. Roosevelt in 1936, who was denied the Agricultural Adjustment Act. During the Great Depression, President Roosevelt tried to revitalize the farm industry and restore purchasing power to them. His Agricultural Adjustment Act taxed processed farm product companies to generate subsidies for farmers. The Supreme Court ruled the act unconstitutional, as the government could not levy a tax on companies merely to have that money paid back to farmers. However, the act was adjusted 2 years later and continued in its new form. In this case, President 1, Supreme Court 0. In 1952, Harry S. Truman was denied the power to take over U.S. steel mills. During the Korean War, U.S. steel mills threatened a massive strike. Fearing that it would halt steel production during the war, President Harry Truman ordered his Secretary of Commerce to take over all the steel mills in the United States. The Supreme Court ruled a few weeks later that this action was unconstitutional, thereby allowing steel workers to strike. The world did not end. President 0, Supreme Court 1. In 1974, President Richard Nixon was refused executive privilege. During the Watergate indictments, President Richard Nixon refused to release the tapes recorded in the White House during his presidency, claiming executive privilege for the purpose of national security. The Supreme Court ruled unanimously against him. The House Judiciary Committee, which was then considering articles of impeachment against President Nixon, stated clearly that if President Nixon did not turn over the tapes, that refusal in and of itself could be considered grounds for impeachment. 8 hours after the decision, the tapes were released to the House of Representatives. President Nixon resigned from office 2 weeks later, becoming the first U.S. president to do so. Score: President 0, Supreme Court 1. Next, in 1996, Bill Clinton was refused presidential immunity. President Clinton was involved in a civil law case called Clinton versus Jones, where he was accused of sexual harassment by Paula Jones. He endeavored to get the case dismissed on the grounds of presidential immunity. A judge denied the request, and the Supreme Court ruled that a president is not immune to civil law cases while in office. He was eventually found in contempt of court for perjury about a sexual relationship with Monica Lewinsky, leading to his impeachment, though eventually he was acquitted of all charges. Score: President 0, Supreme Court 1. In 2006, George W. Bush ignored the congressional requirement for Guantanamo Bay military trials. President George W. Bush, as part of his post-9/11 security strategy, ordered military trials for detainees at Guantanamo Bay. The Supreme Court, though, ruled that he could not do this without congressional approval for tribunals. Otherwise, he'd be violating international law. Score: President 0, Supreme Court 1. In 2014, Barack Obama defied the Senate in government appointments. When the Senate is in recess, the president can temporarily appoint individuals to government posts while the Senate is not in session. President Obama made government appointments while the Senate usually takes recess. However, the Senate had not officially declared itself in recess at that time. A suit was brought against the president, and the Supreme Court unanimously ruled against President Obama. President 0, Supreme Court 1. In 2017, Donald Trump was prevented from closing DACA by a federal court and ultimately the Supreme Court. During his first term in office, President Donald Trump wanted to shut down the DACA program. DACA stands for Deferred Action for Childhood Arrivals, which President Obama created in 2012 by executive order. The U.S. Court of Appeals of the Ninth Circuit ordered the president to continue the program. The Supreme Court ruled that the Trump administration's attempt to end DACA was illegal, allowing the program to continue for those already enrolled. Nevertheless, his administration moved to fortify the program and work toward a more permanent solution. However, DACA's future still remains uncertain due to ongoing legal challenges and the lack of a comprehensive immigration reform from Congress. Score: President 0, Supreme Court 1. Now, the previous administration of the United States presidency. In 2024, President Joe Biden defied the Supreme Court on student loan forgiveness. Andrew Jackson invited the Chief Justice to try to stop him. President Joe Biden, in February of 2024, after ignoring the Supreme Court's landmark 2023 ruling that his previous loan forgiveness plan was illegal, boasted, "The Supreme Court blocked it, but that didn't stop me." He wrote off student loan debt twice, bringing the total to $138 billion. Admittedly, he did not actually cancel the debt. He transferred it from the borrowers to the taxpayers to finance it. Score: President 1, Supreme Court 0. How presidential defiance of the Supreme Court will work in the future is anyone's guess, but there is historical precedence for it, more often than most people would think. What can we learn from history? Thank you for listening. I'm Bill Petro, your friendly neighborhood historian. You can find more details on this topic and others on my website at billpetro.com.